if transmission is assigned in the way that staff proposes, it basically creates a disincentive for people like Facebook to move into Mexico, because there's this basically upfront fee they have to pay rather than paying for it over time. It'd be like, okay, yeah, you can move into this neighborhood, but we need the whole price of the house now, instead of being able to finance it as you use it. So you're never going to move into that neighborhood, right? You can afford a $2,000 a month payment, but you can't afford $350,000 out of pocket. It's the same kind of thing. Nobody's going to come in and say, okay, extra 85 million, boom, off the bottom, off the top, you know? So that's the real issue. But more from a regulatory standpoint, from an orderly how you develop rates, it's not how it's done. It's not like the newest customer pays for the newest generation unit. It's not like if you moved into Albuquerque, they said, well, we just installed 20 megawatts of solar and there's 300 customers moved in the last month, so you owe us an extra $10,000 to pay for that 40 megawatts of solar because you made us buy it because we wouldn't have needed it if you hadn't moved in.
And that's what you're.
That's really what happens is postage stamp. That 40 megawatts of solar gets added to everybody's rates. You pay a part of it when you pay every month. And that's the logical only way to do it. And staff is saying, no. Newest customer pays the newest for the newest piece of equipment. Crazy. I don't even know how they got all this.
That would just be so random.
Yeah, it is totally random. So you've got this one piece of interconnection on the system that's being paid for in one way, and everything else is being paid for in another way. It's crazy. So we'll just see how it goes. But he's obviously invested in it, so I'm glad I touched base with him because he's just feel how pissed he is kind of interesting. Okay.
Allison, before we go on the record, I have a question for you.
Sure.
I think Anna Kippenbrock told you that PNM had agreed to pay to expedite the transcript in this case.
That's what I understood. You had a 3-day expedite.
Okay, so I was just wondering what day that would be, do you think?
Well,
That we would get?
3-day would put you into next Wednesday, but my guess is, depending on how long it goes today, that it would be before that.
Okay. Thank you.
Tuesday-ish.
Okay, thanks.
And Ms. Padilla, is that correct? You're requesting a 3-day expedite?
Yes.
Madam Hearing Examiner?
Yes,
Allison, I can either indicate Mr. Meyer as being previously sworn yesterday, or if you prefer, I can swear him in again.
it's okay with me to indicate that he was previously sworn.
All right, thank you.
Thanks for asking. Well, it's 9 o'clock. Allison, are you ready to go on the record? Okay. Let's go on the record. We are back today to resume the hearing in case 20-00124-UT. And at this time, PNM, you may cross-examine Mr. Meyer.
Thank you. This is Ryan German. I'll be doing the cross-examination. Can you hear me, Madam Hearing Examiner?
I can, very well.
Okay, thank you. Good morning, Mr. Meyer.
Morning, Mr. German.
Do you have a copy of the Commission's Renewable Energy Rule, Rule 572?
No, I do not.
Do you have a copy of the Renewable Energy Act?
I do have that.
Okay. Are you aware that the Commission's Renewable Energy Rule, Rule 572, requires utilities to offer voluntary renewable energy programs?
I believe I've read something in the testimony referencing a section in 572 to that degree.
Okay. And are you also aware that Rule 572 provides that utilities shall recover their costs of complying with Rule 572?
That I'm not familiar with that specific portion of 572.
Okay. But it's your understanding that PNM proposed the Sky Blue program to comply with Rule 572, right?
I would assume that the Sky Blue program is in compliance with 572. Otherwise, someone would have raised some type of objection to the program.
Okay. And the Commission ordered PNM to implement the Sky Blue program in case 10-00018, right?
That's when it was modified, I believe, yes.
Okay. And what I'm getting at here is that just trying to understand Animaria's position. I understand Animaria's position to be that you're not necessarily opposed to PNM's recovery of reasonable Sky Blue costs. What your issue is the accounting for the RECs associated with Sky Blue that PNM has presented in this case. Is that a fair summary of Animaria's position?
Let me just restate it and see if this answers your question. We're not opposed, Pnm area is not opposed to the recovery of the prudent cost of Sky Blue. And in fact, it may be that once all the documentation is provided, that we have no objections to the totals seeking to be recovered. Our position in this case is that during the numerous times when PNM has had the opportunity to provide what I call or what would be considered a complete audit of those costs and justification for their recovery, it doesn't seem like that has been provided at this point.
Okay. Mr. Meyer, could you open the Renewable Energy Act? And I'd like to direct your attention to section 5. So it's 62.16.5 B2.
I'm there.
Okay. And you see the second sentence from the end of that paragraph that starts, "The commission shall not."
Yes.
Could you just read that sentence to yourself?
Yes, I've done it.
Okay. So do you agree that that section of the Renewable Energy Act provides that the commission shall not disallow the recovery of costs associated with any expired Sky Blue RECs?
I can't make that stretch.
Okay.
I understand that this sentence says that that because of a REC expiration, that cost recovery can't be disallowed, but I don't see how that could tie into Sky Blue.
And could you read, just to yourself, read the next sentence in that same section that starts the public utility and then parts A and B underneath that sentence?
I read it.
Madam Hearing Examiner, this is Peter Gould. I'd like to make an objection at this point.
Go ahead.
Mr. Meyer is not an attorney, and it seems as if in these questions, Mr. German is asking Mr. Meyer to make legal conclusions about statutory language, which is beyond the scope of his testimony and beyond the scope of his expertise.
Mr. German?
Yeah, I'm just asking Mr. Meyer to apply these sections of the Renewable Energy Act to the facts of this case, and he can answer to the extent he has sufficient knowledge to do so, but I'm not asking him to provide a legal opinion.
Madam Hearing Examiner, that's exactly what attorneys do, is apply a statutory language to the fact of the case, and that's what we're trying to get to do. And so I think Mr. German's response just shows that he's asking for a legal conclusion.
I remember the first question you asked Mr. German about Mr. Meyer's interpretation of the language that the commission shall not disallow the recovery, blah, blah, blah. What was your second question to him?
Yeah, so I haven't asked a second one. I just asked him
Oh.
to read the next sentence in that section of the REA.
Okay,
Sorry.
I'm overruling the objection until I hear the question.
Mr. Meyer, is Animaria challenging or asserting in this case that PNM's renewable energy reports, the annual reports that it files to the commission, have violated any provision of the Renewable Energy Act?
Madam Hearing Examiner Peter Gould,
Go ahead.
I do think that's specifically asking for a legal conclusion. We'll address that in our brief.
Yeah, it's just asking for Animaria's position. I'm not asking him for the legal support for that position. I'm just asking what position they're taking in the case.
I'll allow the question insofar as it asks whether Mr. Meyer has argued that, because I do think it could be something that Mr. Gould chooses to raise in a brief that Mr. Meyer may not be aware of. So Mr. Meyer, have you yourself made that argument in testimony?
And I apologize, I'm going to have to ask Mr. German to repeat the question.
Sure. So, Mr. Meyer, have you made the argument in testimony that PNM's annual renewable energy reports have been inconsistent or have not complied with either the Renewable Energy Act or Commission Rule 572?
The basis for my testimony has not relied on the renewable energy or the annual reports filed by PNM.
Okay. There was some testimony yesterday from Mr. Gutierrez and then again from Mr. Babe that one way to determine the per rec cost of the reg assets or to determine the RPS compliance cost of the regulatory asset would be to take the regulatory asset amount and divide it by the number of RECs, unexpired Sky Blue RECs that PNM is proposing to retire in 2021. And I believe the testimony that Mr. Gutierrez gave was that that dollar per REC would be $121.86. Do you recall that testimony?
This is Peter Gould. I'm not objecting, Madam Hearing Examiner. Just for the sake of the record, Mr. Ryan, could you point exactly to the schedule in Mr. Gutierrez's testimony that you're referring to so Mr. Meyer can look at that and we can have a competent answer for that question? Thank you.
So it was Mr. Gutierrez's rebuttal testimony in SG1. As corrected, sorry.
I was just going to point out that he corrected that number at the hearing.
Right, right.
And Mr. German, this is his exhibit SG1 rebuttal, page 2 of 3 that you're referring to?
That's correct.
Okay, and line 34, is that where you're at?
Yes, that's correct.
Thank you. Thank you.
I think I remember the question. The 121.86 is derived merely by dividing the available, or what PNM claims is the RECs associated with Sky Blue that have not expired, divided by the total revenue requirement shortfall that exists over the 8-year period of $2,317,329.
Mm-hmm. Right, right. And I'm not going to ask you about that specific dollar amount because I understand that Animaria might have a different position than PNM on the number of RECs that are available for the number of RECs associated with Sky Blue that would be available to retire for RPS purposes in 2021, and maybe even a disagreement on the dollar amount of the regulatory asset. But what I want to ask you about is just that method of determining the RPS compliance costs, taking the regulatory asset value and dividing it by the number of available RECs. Does Animaria agree with that method?
I have no reason to object to that, except as you pointed out, there could be adjustments to both the costs and the available recs that should be applied here.
Okay. Okay, understood. And is Inamaria proposing a different method in this case for determining the RPS compliance costs of any Sky Blue Recs?
Well, I guess, Mr. Chairman, I'll go back to our original statements. We have no way of knowing what the proper valuation for Sky Blue is at this time, given the, what I'll call the lack of documentation, complete documentation surrounding the regulatory asset and the claimed recs that are unexpired.
Yeah, understood. So I understand Inamaria does not necessarily agree with the reg asset amount or the number of recs that are available. But again, I'm asking you just about the methodology. Is Inamaria proposing a different methodology than taking that total reg asset dollar amount and dividing it by the available recs?
At this point, we have no problem with how you've shown it on the schedule.
Okay.
Given our concerns still about the recs and the regulatory asset value.
Okay. Is it your understanding that in case 1018, the commission ordered PNM to try to sell unretired Sky Blue Recs to third parties?
Madam Hearing Examiner, Mr. Gould, this is not an objection, but again, could Mr. German point Mr. Meyer to the exact page and language in the 10-000-18 order? It's pretty massive, so we'd like that clarification, please.
If that can be done quickly, I'll allow it. Otherwise, I will not allow the question.
Okay. And Mr. Meyer, you have the 1018 final order and recommended decision in front of you?
I have the post remand final order. There were several, so I just have the post remand.
Right, that's the one. So if you could look at page 4 of that post remand final order, and it's paragraph B at the top of that page.
I have.
Okay. And you see that paragraph B at the top of page 4 requires PNM to use reasonable and prudent efforts to sell recs not used for the voluntary program to third parties.
Yes.
Okay. And do you recall testimony in this case that PNM has been able to sell a small number of recs to third parties?
40 recs.
40 recs, I believe, for $200. Does that sound right?
That's correct.
Okay. So that would be a per rec cost of $5 then, right?
Yeah, that's my math.
Okay, good. Okay, so my next question is that, so according to the methodology that we just discussed, the methodology that Mr. Gutierrez used to calculate the RPS compliance cost. So according to that methodology, the price that PNM has been able to sell recs at on the market is much lower than the RPS compliance cost proposed in this case, right?
Well, if your question is it's $5 less than 121.86, the answer is yes. But I think those are measuring different components, so to speak.
Okay. Do you agree that the requirement that PNM sell unexpired recs to third parties benefits PNM's customers because it reduces the regulatory asset balance?
The sale of RECs is supposed to be used to reduce the regulatory asset. To the extent that those RECs are sold and are not included then in the cost of the RPS regulatory asset, or I'm sorry, the regulatory asset, then yes, those costs at that point are less than what they would have been otherwise.
Okay.
I'm not suggesting, though, I haven't looked at what the total implications would be for a sale of a $5 rec versus the total revenue requirement of PNM.
Okay. And I think in your previous answer, you said that the RECs sold on the market have different components than the RPS compliance RECs. Can you explain what you mean by that, or maybe I'm misquoting you? Let me know.
Yeah, I think-
Madam Hearing Examiner Peter Gould, objection.
Go ahead.
The question assumes that these are RPS compliance recs, which goes to the heart of your bench request, which Anna Mary does not believe. That fundamental question has been answered by PNM. That's one of our issues. So if the question can be restated to not characterize these as RPS compliance recs, we have no objection. Otherwise, I object.
Mr. German, are you amenable to that?
Yes. Mhm.
Go ahead, Ben.
Yeah. And so, Mr. Meyer, I really just want to ask you to explain what I think your previous testimony was, that the RECs sold on the market have different components than the RECs associated with the Sky Blue program. So is that what you said? And if so, could you explain what those different components are?
I'm not sure that you characterized my answer correctly. So I mean, if it's possible, I'd like to have that read back to me.
Mm-hmm.
Was that from yesterday?
No, it was the answer he just gave. And if I'm misremembering it or misquoting it, then that's fine. We can move on.
Okay, let's move on then.
Okay. So, Mr. Meyer, to the extent a REC sold on the market has a lower value or a lower cost than is associated with that REC in the Sky Blue regulatory asset, should PNM be permitted to recover the difference?
I can honestly tell you, I haven't thought of that proposal at this point.
Mm-hmm. But if the costs in the regulatory asset are shown to be reasonable and prudent, do you agree that they should be recoverable?
It would seem to me that if you had a REC that was dedicated for Sky Blue that you could not use, and you sold that REC for less than its cost, with the provision that you have a regulatory asset, I believe that it would be a reasonable conclusion that you should be able to book that to the regulatory asset.
Okay.
But that does not, just so we're clear, that does not guarantee you, the booking to the regulatory asset should not guarantee you rate recovery.
Okay. But doing that, so selling a REC at less than its Sky Blue cost, doing that would have the effect of, according to Mr. Gutierrez's methodology of determining the per REC cost. So selling a market on the, sorry, let me start again. I'm confusing myself even here. So selling a REC on the market at below the Sky Blue REC cost would have the effect of increasing the per REC, what I'm calling RPS compliance cost that Mr. Gutierrez presents in his rebuttal testimony. Is that correct?
So let me see if I can answer it this way.
Mm-hmm.
To the extent that you sell RECs in the market that are less than the compliance cost from Sky Blue, and those RECs are deducted from the bank the rec bank that you use to calculate the cost per rec for Mr. Gutierrez's Schedule 2, the cost will increase per rec due to the less recs that are available for the Sky Blue for RPS compliance versus if they had not been sold.
Okay, thank you.
Mr. German?
Yes.
The way it's presented on line 34 right now is 19,016 recs, which is the 19,708 that has been identified previously, less 40 recs that were sold, less the 652 recs that expired. That gives you 19,016 recs. However, the cost associated with the regulatory asset has not changed from the I'll just use a round number, 2.3 million. So if the recs had not been sold, then you would have had 19,056 recs divided by the 2.3 million, and the cost would have been less per rec.
Correct. But I think in that hypothetical, the $200 sale price would have to be added back into the reg asset balance. Do you agree with that?
No.
I'm sorry?
No.
And why not?
Okay, I'm sorry. If you increase the recs back to 1956, then you would have to add back $200 to the reg asset, correct?
Right.
But it would still result in a lower number than the one that's listed on line 34.
Yes. Yes. Thank you. I agree with that. That's all I have. Thank you, Mr. Meyer.
Thank you.
Ms. Zur.
I don't have any questions. Thank you.
Ms. Nanazi.
Thank you. I have a couple. Good morning, Mr. Meyer.
Good morning.
In your capacity as a regulatory analyst and auditor in other jurisdictions, have you analyzed and reviewed regulatory assets like this?
I've not been exposed to a reg asset associated with a RPS compliance cost or a special program associated with a utility purchasing renewable energies. I do have extensive experience in regulatory assets and their use in regulatory matters.
Have you encountered a regulatory asset as open-ended and non-time limited as this one?
No. Typically, when I deal with regulatory assets in other jurisdictions, we make sure that there is a definitive time period that the regulatory asset would be in place for. I'm currently working on several accounting authority orders or authorizations, AAOs, dealing with COVID, which would result in regulatory assets being established. And one of the big issues in the negotiations is the term. By having a regulatory asset that does not have an end date, essentially what you've done is you've turned the regulatory asset that are the deferral of costs into a tracker. And then in this case, the tracker is that PNM tracks the revenues less the expenses for Sky Blue and takes that difference and applies it or records it into a regulatory asset. And they've been doing this for, according to Mr. Baker's Schedule 10, approximately 8 years. And so, no, I haven't seen something like this.
Can you explain further what you mean about the tracker?
Objection, Ryan German.
Go ahead.
I object to this line of questioning on the grounds that it's friendly cross. NEE and Pnm area are aligned on this issue.
So before I ask you to respond, Ms. Nanazi, I'll just remind you that I did say in my pre-hearing order that friendly cross-examination is generally prohibited. Friendly cross-examination is cross-examination of a witness by a party who does not disagree with the witness's position on an issue. So what position do you disagree with on Pnm area that would justify this questioning?
Well, frankly, New Energy Economy has not taken the position about the tracking. We have not taken that position. The thing that we've been opposed to is different. And you know, by my questioning and by my submissions in this case, we haven't talked about tracking or this regulatory asset at all. So I wanted to ask him about it, given his experience. I just read his testimony, so I don't have any, I'm curious about this position. I don't know if that we have the same position, frankly.
Okay, I will allow the question.
Thank you. I really don't have that many more questions. I just want to ask, could you please tell me what you, or tell us what you mean by the tracking? What does that mean?
A tracker will take one aspect of the company's operations and track the difference. In this case, they're tracking the difference between the revenues received from Sky Blue customers and the cost of the Sky Blue program. They're tracking those two and determining at the end of each year what the shortfall or over collection is for that particular piece of the operations of PNM. They then take, in this case, it's 7 out of 8 years, the shortfall, and record those to a regulatory asset where they then apply carrying costs.
So is sort of the heart of your testimony that you have concerns about the way that PNM has tracked, that the system is complicated and that the evidence has not been detailed? Is that the heart of your testimony?
The heart of our testimony is that PNM has not provided sufficient documentation on all aspects of the Sky Blue costs and revenues received and associated RECs to make a determination whether the total regulatory asset is the correct balance to be recovered from ratepayers, and also the period over which the regulatory asset should be recovered.
Thank you. No further questions.
Mr. Harris.
Yes, I have a few questions. Good morning, Mr. Meyer.
Morning, Ms. Harris.
Okay, this morning on cross-examination, you had mentioned, and I'll paraphrase, that a utility is entitled to recover prudently incurred costs. Is there anything in the record that you have seen that raises any red flags about prudency issues?
I have not done a thorough examination of the prudency of the costs. However, that can extend to the question about whether expired RECs from the Sky Blue program should be allowed for recovery in the regulatory asset.
Okay, and I believe you have mentioned somewhere, maybe it was in your rebuttal, about the duty to the commission has to balance the interests of ratepayers and shareholders. Is there anything that you have seen in here that raises a red flag on fair balancing of interests?
The balancing argument was raised in conjunction with the carrying cost issue.
That's correct.
The use of a carrying cost less than the weighted average cost of capital, I've argued in several instances, is a sharing between the shareholder and the ratepayer. And in that, I mean that in exchange for the special regulatory tool, which I would refer to as the regulatory asset, that the shareholders then are only compensated by a lower return, which is a sharing proposal as compared to the full weighted cost of capital return that would be applied in some situations. And I've seen that imposed on several occasions.
Okay, thank you. I have no further questions.
Ms. Yee?
Madam Hearing Examiner, I have no questions for Mr. Meyer or for any of the remaining witnesses. Thank you.
Mr. Borman?
Thank you, Madam Hearing Examiner. I have no questions for Mr. Meyer.
Mr. Meyer, I have some questions for you. Yesterday in your SIR rebuttal, you listed some concerns you had, and one was that there's no documentation of the RECs associated with the New Mexico Wind Energy Center. Why is that needed?
Well, from what I understood yesterday and just the reading of Mr., I believe it's Bobby's testimony, the wind RECs and the solar RECs are very much intermingled in that depending on the revenues that are received from Sky Blue customers, there has to be I'll say an allocation between wind and solar to make the best there, to optimize the use of those RECs for the Sky Blue program. Without knowing how the RECs from the Wind Energy Center are being treated and how they've been treated historically, would lend some light on why we're facing this problem with the solar RECs and how these have accumulated over the years, and how now there is this question about what I'll call retired solar RECs versus there wasn't seen to be any problem with the wind energy RECs containing or being used in a current fashion for RPS. So it's just basically to get the whole picture all at once to understand the whole program.
So if RECs from the New Mexico Wind Energy Center allocated to Sky Blue, if those have been retired, should the cost associated with those RECs be allowed to be recovered through the Sky Blue regulatory asset?
If you can demonstrate that you have not collected those costs in another way through RPS, then yes, they would be eligible for recovery in the Sky Blue regulatory asset. It's just what we just want to make sure is that there aren't RECs that aren't being used for RPS compliance that couldn't be used for Sky Blue that are included in the reg asset, or that we want to also make sure that the wind assets aren't facing similar situation that what we consider the solar RECs to be facing, and that you have RECs that have extended beyond 4 years that weren't used for RPS compliance, and then the argument would come to the commission on whether those RECs should even be included as well.
Okay.
We just need a picture, to be honest with you.
Did you hear Dr. Pitts's testimony yesterday? I asked her whether Mr. Baker's Exhibit 10 which lists the costs of the regulatory asset by year, whether that included the costs of retired recs. And I believe her answer was she thought it probably did. Do you recall that?
I was here from Ms. Pitts. I don't specifically recall the question about the retired recs.
Okay, let me rephrase my question then.
Sure.
If the balance of the Sky Blue regulatory asset includes retired recs, the cost of retired recs, should those costs be allowed to be recovered?
Okay, and I'll give you a two-part answer, I guess, so to speak. If it can be demonstrated that the wind recs were used for RPS compliance and included in the rate calculation for RPS compliance, then to suggest that it could also be included through the reg asset would be double recovery, and that would be a problem. So the audit trail or the audit scope should include a way to reconcile between the Sky Blue program costs, regulatory asset costs, and what was included in RPS compliance to make sure that there isn't this overlap or double recovery possibility.
Okay, and related to that, did you hear my question to Mr. Babe yesterday when I asked him in relation to his exhibit attached to his supplemental testimony, whether all the Manzano recs generated in 2014 had been retired? And do you recall him saying yes?
I do recall that line of questioning.
Okay.
My schedule that I put together on a year-by-year basis would suggest that in 2014, coming out of 2014, there was some excess recs, but those could have been used and should have been used for 2015 compliance.
Okay, so this might be a repetitive question, but if those recs from 2014 have been retired, should PNM be allowed to recover the costs of those 2014 recs through its Sky Blue regulatory asset?
Well, they were, the full amount, just so we're clear, the full amount of recs in 2014 could not have been all retired in 2014 because the Manzano produced more recs than Sky Blue could use. Just narrowing it down for 2014 alone, I'll just give you some figures. Manzano produced 35, I'll just use round numbers, approximately 3,500 megawatt hours, and Sky Blue's consumption from Manzano under Rider 30 was only 1,600. So there was approximately 1,900 of excess recs in that year. Now, you have to remember that in 2013, the subscription for Rider 30 was much greater than the production from Manzano, which left about 1,000 negative recs that needed to be used in future years, which was the core purpose of the regulatory asset to balance the generation with the use of Rider 30. So coming out of 2014, there was still a, excuse me, there was now an excess balance of recs versus what happened in 2013. So can't really say that all the recs in 2014 were retired in 2014 because that couldn't happen.
Okay, I think, but my question to Mr. Babe was not necessarily that they were all retired in 2014, but over the course of time, they have all been retired.
Now,
and my understanding was his answer was yes.
And by my year-to-year analysis, I would support that answer.
So my question to you is, if all those recs associated with generation from Manzano in 2014 have already been retired, should PNM be allowed to recover the cost of those 2014 wrecks through its Sky Blue regulatory asset?
Okay. And I think what you have here is a potential timing difference for the recovery and the recognition of the regulatory asset. Because the production from Monsanto exceeded the demand, I would expect that the costs, that just the natural progression would be that the costs were not completely recovered during 2014 for those wrecks. So there would be, in my mind, the potential for a positive regulatory asset in that regard. And your comparison can be, if you look at TSB 10 under 2013, where the subscription, where the Rider 30 consumption was greater than Monsanto, you saw that you had a negative regulatory, what I'll call a regulatory liability in that year, which was then offset in future years with regulatory assets.
But if the cost of the 2014 wrecks has been recovered, not necessarily in 2014, but over the course of some amount of years, should that cost be allowed to be recovered again through the asset?
Should that cost be allowed to recover? I didn't hear the last part.
Should that cost be allowed to be recovered again through the regulatory asset?
I have no knowledge that they are attempting to double recover those costs twice through the regulatory asset. The main concern, as we discussed earlier, would be whether the costs were included in the RPS compliance and then also included in the regulatory asset. But I have no knowledge to suggest that PNM is attempting to recover twice through the regulatory asset. For specific wrecks within the reg asset. I'm not convinced, I haven't seen the evidence that your argument before about double recovery through RPS compliance and Sky Blue, I don't have, the documentation hasn't been provided to verify that statement.
So that's some of the evidence that you would want to see.
Yes, I mean, we're just interested in seeing the whole, we're not arguing that the information probably isn't available at PNM. We're just suggesting at this point, it hasn't been provided to you or to any of these parties to really verify that the 2.3 is the proper amount of the regulatory asset to be recovered and the associated recs. I think that's another issue that needs to be addressed by the commission.
So you've heard through Mr. Baker's written testimony and his testimony yesterday that PNM has decreased the number of recs that it says are available for compliance in 2021 from what it said in its direct testimony.
Correct.
Okay. So if that's the case, should the amount of the regulatory asset decrease from what PNM has consistently said the amount is?
I think that is definitely an issue that that when the whole record is presented, that should be addressed by this commission and parties. What Mr. Baker has done is he's taken 19,708 recs that I can identify by doing an annual basis from Manzano, and then made two adjustments. 140 for the sale, which would drive it down to 19,668, and two, the 652 that they found that were retired, and I believe in 2014 or 2015 that they didn't have records of. When you divide those down, you now have a rec total of 19,016. But you know, as he divides the recs down, or I'm sorry, as he moves to reduce the rec balance, he makes no adjustment to the regulatory asset, and I think that's an issue that needs to be fully investigated, fully audited, and that would happen, and you would get people's positions after the whole audit trail was provided.
Okay, so you don't have a position on that right now?
No, I don't. I think that we would need to have more discussions with PNM, but first I think PNM needs to provide more information at this point.
So do you understand from PNM's testimony that it is proposing to apply an 8.64 carrying charge to the regulatory balance up and until it is recovered, and then is proposing to apply a 4% carrying charge after the regulatory asset is recovered? Do you understand?
I understand that that's their position. I don't necessarily agree with it, but I understand it.
Is it appropriate to apply a carrying charge after an asset has been recovered?
No, absolutely not. No, because there's nothing there to carry. Just so we're clear, from my limited review of the record, the 8.64% was the weighted cost of capital that was to be applied to Manzano's, and I think this was in the proposal in the 10-00018 case. 8.64% was to be applied to the Manzano 2 megawatts, or in this case, 1.5 megawatts total revenue requirement. And then the fuel costs that were collected for Manzano and the Sky Blue rider were used to offset that asset. So, and I would agree with that. That the 8.64 is the weighted cost of capital. That would be the appropriate carrying charge to apply to that investment. But I can't see where, and I saw Mr. I think it's Baker's testimony where he references another order in 12,000, I don't have it right here in front of me, where he references page 7. That asset is the revenue requirement associated with the investment in Manzano. It does not, in my mind, relate to the carrying cost associated with the regulatory asset. Furthermore, in 10-00018 UT, there's testimony or there's discussions that the 1.7, or the 0.017 and the 0.025 rates already include carrying costs. So that's another issue that needs to be fully addressed by the parties, and hopefully the documentation provided by PNM would clear that up as well. But right now it's murky at best.
Did you read Shane Gutierrez's rebuttal testimony in which he made changes to your calculation of the banked recs, and then he made some additional changes to those numbers yesterday at the hearing? Are you familiar with those?
I am.
Do you agree with his modifications?
I agree with I believe he changed the 68,000 to 30. And that was a result of the last RPS case where at the beginning, Mr. Gutierrez did the calculation, but did not, I don't believe, reflect the full offset of the renewable energy program participants' usage. When that was done, I agree with you that the 68, so his number was a 68, and that was his pre-filed direct testimony. The 30 is the result of the new calculation. And the only concern I have with his testimony now is, it's my understanding when I reviewed the, and I can get it here real quick. Well, I don't have it right in front of me here, but when I reviewed the schedule that determined the 30,000 shortfall, we had already accounted for the surplus from the prior year. So I would just like to have probably an off bar with Mr. Gutierrez to see if he agrees with me that prior year's excesses has already been accounted for when we arrived at the 30,000 shortfall.
All right. That's all I have. Thank you.
Thank you.
Before I go to redirect, I want to ask who the person is who's participating with the phone number 831-566-5832.
Madam Hearing Examiner, that's the reporter. I was booted out again.
Oh,
I got back in. I've been reporting the last 13 minutes via phone. I don't know what I can read you. Can we go off the record?
sure.
I apologize. I have not had this much trouble before. Let me go to where I went out and where I picked up.
Thanks.
I'm hearing from my tech husband that there is an outage in the area. Okay, so I got through the hearing examiner's questioning. Okay, the last question that I had before I went out was, okay, so this might be a repetitive question, but if those RECs from 2014 had been retired, should PNM be allowed to recover the cost of those 2014 RECs through its Sky Blue regulatory asset? And I don't know how long I was out. As soon as I got back in, I have the witness starting off saying production from Manzano exceeded the demands. I would expect that the cost, that is the natural progression, would be the costs that were not completely recovered during 2014 for those RECs. So there would be, in my mind, the potential for a positive regulatory asset in that regard. And I have from there until now.
Okay. Mr. Meyer, did you want to add anything to that might have been missed?
I don't think so, hearing examiner. Thank you, though.
Okay. Allison, did you want to take a break to see if you can get back on?
I would like to take a brief break. I have an outage, but I can get on a better quality phone if I have a brief break.
Okay. Why don't we take a break until 10 o'clock?
Thank you. I apologize.
No problem. Allison, are you ready?
Yes, I am.
Okay, let's go back on the record. Mr. Gould, you may proceed with any redirect.
Madam Hearing Examiner, thank you. I have no redirect.
Okay. Mr. German? Okay, Mr. German is not present, so he waives his recross. Ms. Zur? Ms. Zur is not present, waives her recross. Ms. Nanazi?
No questions, thank you.
Mr. Harris?
No questions, thank you.
Ms. Yee?
No questions.
Mr. Borman?
I have no questions.
Okay, thank you, Mr. Meyer, very much. You're excused.
Thank you.
And Mr. Borman, you may call your first witness.
Thank you. Staff calls John Reynolds, please.
Madam Hearing Examiner, Mr. Gould, objection at this point.
Go ahead.
As you're aware, I sent you and the parties an email on Tuesday or Wednesday, actually the day before the hearing, regarding the issue of the conformity of staff's testimony on the Dropbox with your motion to strike. And I had a call with Mr. Borman this morning. And I think we're in agreement with part of what we need to do. And I'll let him speak. And we're not in agreement on the other part of my email request. And I just wanted to know what would be the most expeditious way for us to handle this issue. Essentially, it's an issue of whether or not all the testimony on the Dropbox has been properly stricken through to comport with your motion, your order granting your motion to strike.
Well, Mr. Borman, why don't you tell me what's been agreed to and what is not agreed to?
Well, here's what I can tell you. Staff endeavored to follow your order to the letter. And to the extent that what we uploaded does not follow the specific directive that you made in that order, the vote for that is mine, and we would agree to make whatever corrections that you identify to that. But it seems to me that what Mr. Gould has asked for, at least in his email, goes beyond just simply following the directive that you set forth in your order. Basically, he's seeking changes to staff testimony beyond that. And to me, that's basically a request to reconsider or clarify your order. And we think that that's untimely. I mean, we've had your order for more than 2 weeks, and he had an opportunity to review that order and decide if there was anything additional that needed to be added or anything that needed that you did not address that he had raised. You know, we had 2 working days to respond to Mr. Gould's motion, and he's had 2 weeks now to identify anything in your order that did not comport with what he asked for. So we would request that anything beyond what you expressly directed in your order be denied.
Mr. Gould?
Madam Hearing Examiner, let me make sure I'm okay. I'm not on mute. If we could address it in 2 parts, that maybe for the clarity of the record, the portion that Mr. Borman seems to agree with, and we can clarify those deletions, and then we can go to the second part. Would that be a proper procedure?
Sure.
Okay. The first thing we noticed on Mr. Reynolds' direct, we had asked in the motion to strike the joint movements to remove the entirety of Mr. Reynolds' attachment JJR2. The Dropbox version still has the header to that JJR2 attachment, which reads BB2 transmission line dash allocation of cost to La Jolla 2, and we'd ask that to be stricken through. The second change is in Miss Eschberger's, I hope I'm pronouncing her name correctly, direct. On page 5, she has a staff table B as in boy, S as in Sam, E as in Edward -1. And we had asked the entire right-hand column, far right-hand column be stricken, but the header, which reads staff position, was not stricken. And then in Mr. Tupler's direct on page 16, line 10, the phrase with modifications and recalculations recommended by staff and filed, that was requested to be stricken and granted, but it was not in the Dropbox version.
Mr. Borman, do you want to respond to those?
Well, I'm trying to go through all these right now. So, I mean, I'm not sure, at least insofar as the issue on, sorry, I got too many windows open here. I'm trying to work through them. You know, I don't necessarily have a problem, for instance, with striking in Mr. Reynolds' testimony the header for JJR2. I mean, I don't think that's anything. I think what your order had indicated was that JJR2 in its entirety would be stricken, and I think striking the header is fine. I think it was just a technical glitch in terms of getting that crossed out, and I don't object to that. I'm looking for Ms. Eschberger's right now. I got that. All right.
Yeah, Brad, it's page 5 that there's a table. Yeah.
I got it.
Okay.
I mean, again, I don't particularly have heartburn about striking it, but I don't think it makes a difference. And so certainly if the hearing examiner directs us to strike that one basically statement staff position, I will not object to that. And now I got to find Mr. Tupler's.
And before you go on to Mr. Tupler's,
yeah,
I actually denied that part of the request for motion to strike in footnote 1 on page 6 of my order granting the expedited joint motion to strike. And what I said in that footnote is that the request to strike part of line 10 on page 16 of Mr. Tupler's testimony is denied because staff recommends a change to PNM's rider rate based on staff's recommendation to not allow recovery of a carrying charge on the Sky Blue regulatory asset.
Okay, so Madam Hearing Examiner, I had read that testimony more expansively. So obviously we're going to just remove that request from what we're asking. And thank you for that clarification.
Okay, so I will grant the request to strike the header in attachment JJR2, and I will grant the request to strike the header on Ms. Eschberger's table BSE1.
And then the final issue, which Brad and I are in disagreement.
I'm sorry. It appears that there's some problems with the court reporter. I'm just checking in with that again.
Allison, are you?
I'm joining the meeting as we speak.
So did you lose any of what was just said?
Thank you for checking.
Okay. So Mr. Gould, do you want to respond to Mr. Borman's argument that your other request should not be allowed?
Yes, ma'am. I agree with Mr. Borman in the fact that this particular line of this language, and let's go to page 11 of Mark Tupler's direct. So we're both on the same page.
Mm-hmm.
And line 17 through 19.
Mm-hmm.
And I agree with Mr. Borman that this language was not specifically recognized or brought up in our expedited joint motion to strike. And I noticed it, and my bad, I noticed it when I was going back through testimony. But I do think striking this is consistent with your order granting motion to strike, because this testimony here basically directly refers to the addition of transmission costs to the La Jolla PPA. And in your order to strike on page 5, you basically are correctly stating, and I'm reading, staff attempts to relitigate an issue that was dismissed by the commission in case 19-159. And then further, you reaffirm that in the last paragraph before your ordering paragraphs on page 6. So I think it's just consistent with your order. I apologize for missing that, but I think the record should, in the case, should accurately reflect the sense and the purpose of your motion to strike, and we'll just stop with that, and whatever you want to rule on that, we'll deal with. Thank you.
I'm gonna allow those changes. It is untimely, but I think those changes are appropriate to reflect my ruling. I'm not going to require staff to re-upload the testimonies into Dropbox, making those corrections. The corrections will be reflected through the transcript.
Madam Hearing Examiner, if I may.
Yes.
Well, I believe there is going to be one correction to Mr. Tupler's testimony and a couple of corrections to Mr. Reynolds' testimony that we will be identifying today. So to the extent that there are changes that need to be made, we don't mind making those changes into the final uploaded version. I guess I didn't want to make any previous changes because I didn't want to have 5 different versions of testimonies floating around. That said, if you could identify with specificity exactly the additional changes that you are requesting, so we can make those.
Are you directing that? Were you directing that to Mr. Gould?
I was actually directing it to you, Madam Hearing Examiner.
Okay. So the change on page 11 of Mr. Tupler's testimony is on line 17.
Okay.
And the change is to change 2 adjustments to 1 adjustment.
Okay.
And then the second change is on lines 18 to 19
Mm-hmm.
to exclude the phrase, including a 4.04 million transmission cost increase in the PPA revenue requirement number 2 above. One adjustment. And then the word "and" following that. And then probably, then that's good.
So if I can clarify, this would now read, note that staff witness Reynolds has recommended 1 adjustment to the above, comma, an approximately $621,369 decrease.
Yes.
Okay, thank you for that clarification.
So I guess if you don't mind making those changes and uploading them, if you could do that by noon on Monday.
We will take care of that. And as I indicated, we have some corrections to Mr. Reynolds as well that we will be uploading.
Okay.
And
I'm sorry.
my only final question is, when I upload it, is it possible for me to remove the previous version from Dropbox so there's not 2 versions?
I think it is, but you know what? I can just go ahead and do, I think I can do it for sure. So I'll just go ahead and do that after the hearing.
Okay, thank you.
And so that would be to remove Mr. Reynolds and Mr. Tupler's testimonies. Is that correct?
That would be what I understand.
Okay.
And Madam Hearing Examiner, if I might, just one last point. I would like to apologize to staff and to you for when we were jointly drafting this, catching the changes on page 11 that we should have requested. So to the extent that we've added to everybody's work in this difficult hearing, I'd like to apologize to Mr. Borman and to you, and thank you. And with that, we have no objection to the introduction of any of the staff's testimony.
Mr. Borman, then you may call your first witness.
All right, I will call once again John Reynolds to the stand.
Mr. Reynolds, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth? You're muted, sir.
I do.
Thank you.
Good morning, Mr. Reynolds.
Good morning.
By whom are you employed and in what capacity?
I'm employed by the Public Regulation Commission as the Utility Division Director.
As part of your duties in that position, did you review the RPS plan and application filed by PNM in this case?
Yes, I did.
And based upon that review, did you participate or did you prepare or participate in preparing testimony regarding that application?
I did.
Okay, you should have 2 documents that are available to you. Let's start with Staff Exhibit 1. Can you identify that document?
That is my direct testimony in this case, filed on August 28th, 2020.
Was Staff Exhibit 1 prepared by you or under your supervision?
Yes,
Do you have any changes or corrections to staff exhibit 1?
I have some typographical errors. They're all on page 18. And they are reflected in the version that was uploaded to Dropbox. I
Okay.
can go through them if necessary.
Well, can you walk us through those?
Yes.
Okay, thank you.
On line 1, again, this is page 18, and all 3 of them are on page 18. On line 1, the sentence that starts with PNM and the word achieved should be changed to achieve. So the D at the end of the word should be struck. On line 16 of the same page, in the middle of the line, after the word due and before delays, insert to, TO. And line 18, the first word, expect, should be changed to expected, to add ED at the end. That's all I have.
Those are all the changes. Okay. And those are not currently reflected in the version uploaded Dropbox. They will be reflected in the version that we will make upload by Monday. So, okay. Then, if I asked you today the same questions as are set forth in Staff Exhibit 1, would your answers be the same as you have just corrected them?
Yes, based on the information available at that time, that's correct.
Okay. Are those answers true and correct to the best of your knowledge?
Yes, they are.
Okay. Do you adopt Staff Exhibit 1 as corrected and modified as your sworn testimony in this matter?
I do.
And do you also have in front of you a Staff Exhibit 2?
I do.
Can you identify that document?
That is my supplemental testimony filed in this case on September 9th, 2020.
Was Staff Exhibit 2 prepared by you or under your supervision?
Yes.
Do you have any changes or corrections to Staff Exhibit 2?
No.
If I asked you the same questions today as they're set forth in Staff Exhibit 2, would your answers be the same?
Yes.
Are those answers true and correct to the best of your knowledge?
Yes.
Do you adopt Staff Exhibit 2 as your sworn testimony in this matter?
Yes, I do.
Madam Hearing Examiner, at this time, I would move admission of Staff Exhibits 1 and 2.
Is there any objection? Staff Exhibits 1 and 2 are admitted.
Madam Hearing Examiner, I believe you issued an order that allowed oral rebuttal in this case with regard to the supplemental testimony filed by PNM.
I did.
Okay, I would wish to give Mr. Reynolds the opportunity to provide such oral rebuttal.
Go ahead.
Okay, thank you. Mr. Reynolds, do you have some oral rebuttal that you would like to offer in this case?
Yes, I do.
Okay. Do you stand, first of all, I guess, do you stand by the recommendations that you made in your pre-filed testimonies and Staff Exhibits 1 and 2?
I do. However, I recommend that PNM also be required to provide the audit trail documentation recommended by NM area.
Okay, given the supplemental testimony by PNM witnesses Baker and Babe, do you have any additional recommendations?
Yes, I would like to offer recommendations in 3 areas. The first area concerns the so-called swaps, whereby PNM retired Sky Blue allocated Manzano RECs for RPS compliance. And second area concerning the 3,477 Manzano RECs that were allowed to expire. And those include 652 RECs allocated to Sky Blue and the remainder of 2,825 RECs allocated to RPS. And the third area concerns regulatory assets, both the specific Sky Blue assets and regulatory assets in general.
Okay, did you happen to hear the supplemental, or I guess we'd call it oral rebuttal of Mr. Meyer concerning PNM swaps of Sky Blue?
Yes, I did.
Do you have some comments or concerns, or do you share the concerns that Mr. Meyer raised?
To a certain extent, I do. With these swaps, the PNM is effectively, or has effectively been lending these RECs so they can be used for RPS compliance until PNM is in a position to apply the same amount of RECs for Sky Blue purposes. I believe that this is largely analogous to what PNM did at the outset of the Sky Blue program when it had subscribers before it had any RECs. At that point, PNM effectively borrowed RECs to apply to Sky Blue until the Manzano facility began to operate and generate RECs.
Okay. Do you have any additional concerns about those swaps?
And I would agree that there is a certain lack of clarity about the rules of the road for RECs in New Mexico. But I think this matter should be addressed in the current rulemaking proceeding, which is case 19-00296 UT concerning Rule 572 about RPS compliance, and not in this case.
Can you please describe your concerns about the 3,477 Manzano 2015 vintage RECs that expired in 2019?
Yes, PNM witness Babe describes in his supplemental testimony that these 3,477 RECs expired in 2019, and he was unable to explain why that happened. The result of this expiration, apparently unintended, is that PNM can no longer use these RECs for either RPS or Sky Blue compliance, and that other RECs will need to be used instead, thus prematurely depleting PNM's inventory of RECs.
Who pays for these expired RECs, in your opinion?
I believe that PNM ratepayers, subject to the RPS rider, will ultimately pay for these expired RECs unless the commission denies recording the cost of these expired RECs in the Sky Blue regulatory asset. I also believe that PNM is likely to need to recalculate the cost of RPS compliance for the appropriate years.
Why do you believe that PNM ratepayers would be charged like that? And how do you propose to recalculate these costs?
Because it is PNM's position that the balance of the regulatory asset is not tied to the balance of the RECs, but rather to the difference between the Manzano revenue requirement, as well as other costs like advertising and reaches, and the Sky Blue revenues. PNM is effectively avoiding any responsibility for these expired RECs, even though they will need to be replaced with other RECs that ratepayers will also pay for. I believe that ratepayers should be held harmless for a REC value per megawatt hour that would have existed, but for the unintended expiration of the 3,477 RECs.
Based on I guess the supplemental testimonies and the surrebuttal offered by Mr. Meyer and by yourself, do you have any final comments about the regulatory asset?
I believe the Sky Blue regulatory asset illustrates the pitfalls of such an open-ended mechanism. And in this case, it allowed PNM to accumulate the deficits of the program until we've reached the position we are in now.
Thank you. Madam Hearing Examiner, I do not have any additional questions for Mr. Reynolds. He would be available for cross-examination.
Okay. Mr. German or Ms. Padilla?
Yes, thank you, Madam Hearing Examiner. This is Leslie Padilla with PNM. Good morning, Mr. Reynolds. It's good to see you again, if only virtually.
Thank you, Ms. Padilla. Good to see you. Good morning.
I wanted to ask a couple of questions about what Mr. German, I don't have too much, but Mr. German asked Mr. Myers this morning about the statutory basis for the voluntary renewable program and the rule as well. Did you hear that?
I believe I heard most of that, if not all.
And you're familiar with the fact that the Renewable Energy Act requires utilities like PNM to offer voluntary renewable programs, right?
Yes.
Actually, I'm sorry, I misstated that. The Renewable Energy Act allows the commission, I believe the Renewable Energy Act allows the commission to require, let me go ahead and just get it. It says the commission, this is 6216-7, the commission may require that a public utility offer its retail customers a voluntary program. So I may have misstated my question, but that's your understanding, correct?
Yes, that is my understanding, and the commission by rule did require investor-owned utilities to offer voluntary programs.
Do you know when the commission began requiring IOUs to have voluntary programs?
Not exactly, other than what I just said about the rule. Whenever the rule was amended to include that, I don't know when that happened.
Okay, okay. Let's see. Okay, if I could read my writing. In your additional testimony that you just gave in response to Mr. Borman's questions, you stated that with the exceptions that you explained in your oral surrebuttal, that you stood by the recommendations in your direct and your supplemental testimony, correct?
Correct.
So in your supplemental, I wanted to look at page 5 at the top, line 1. You said that you consider it reasonable to consider the costs reflected in the Sky Blue regulatory asset to be RPS compliance costs, and therefore recoverable through PNM's renewable energy rider, right? You see that part of your supplemental?
Yes, I do.
So when I understand through the additional question by Mr. Borman that you have concerns and maybe differences about what the regulatory asset amount should be, but it was your statement that you stand by the recommendations in your supplemental. Would that apply to this conclusion that it's reasonable to consider the costs in the Sky Blue regulatory asset to be RPS compliance costs?
Yes, I believe that's correct. And as I think you just pointed out, I'm not agreeing to the amount that PNM is seeking to recover through the regulatory asset. But I do agree that whatever the commission orders in this case as the amount to be that is reasonable and prudently recorded in the regulatory asset should be recoverable through PNM's renewable energy rider.
Okay. In testimony yesterday, in questioning from the hearing examiner, PNM witness Babe provided some information about, actually he testified, let me back up. Mr. Babe, in questioning from the hearing examiner yesterday, testified that he was confident that no RECs that were retired for RPS purposes would have also been retired for Sky Blue purposes. Do you recall that testimony?
I do recall that.
Okay. And Mr. Babe actually supported his conclusion by discussing the compliance reports that Pnm Files that actually include as attachments the WEC summary of the retired RECs. Do you remember Mr. Babe talking about that?
Generally, yes.
Okay. Those compliance reports that Mr. Babe was discussing are filed every year at the commission, correct?
That's correct.
And I was searching for them earlier, and unfortunately, because we're virtual, I can't show you what I'd like to, but I have examples of some pages of what PNM attaches to those compliance reports. Are you the person at staff, or is someone under you the person who reviews? Actually, let me back up. Does staff review those annual compliance reports that PNM files?
What I can tell you is that I have worked on the last several PNM RPS procurement cases and the last 6 or so. And I've made it my own practice to, as part of my role in those cases, to include a section in my testimony that addresses the compliance report that is filed concurrently with PNM's RPS procurement plan application. So short answer is yes, I review it. And so I'm generally familiar with it.
Okay. And just to be clear for the record, the compliance filings that Mr. Babe, I think, was referring to yesterday aren't, I couldn't find them quickly on the commission's website, but they're not filed in the dockets of the renewable cases. There's some type of other compliance filing that's made every year. Does that sound accurate?
I think in the case of PNM, that's accurate. I'm not going to say that's generally accurate, because I believe that in the case of SPS, for example, I believe they file it in the docket. So different utilities have different practices. I don't recall exactly what El Paso does.
Okay. And so these summaries of RECs that have been retired that are filed with these compliance reports are actually documents. And I'm just asking, do you sort of recall seeing these in your review of these compliance reports? They're WEC reports that list all of the retirements that PNM has made of its renewable energy certificates, right?
Yes, they're, as you say, WEC reports. I mean, that's WECC reports that track RECs and the extent of their lives and their ultimate retirement or expiration. Okay. But I don't go through each REC to make sure that it hasn't been duplicated or I don't review the report to that extent.
Okay. Do you review it to the extent that you recall separate lists or separate designations of RECs that have been retired for RPS? Let me rephrase that one moment. That PNM actually specifically designates in its WEC report that certain RECs have been retired for the Sky Blue program?
I'm aware of reviewing the narrative that is at the front of this compliance report, which may be 8 to 10, 12 pages long. And then in that narrative, PNM describes the number of RECs retired for different purposes, the ones that are retired for Sky Blue, the ones that are retired for RPS purposes. And so PNM does provide that information at a high level in this narrative. And I do review that.
Okay. Okay. Well, if I represent to you that the WEC reports that are attached designate designate whether PNM is retiring a REC for purposes of the RPS or purposes of Sky Blue, would that constitute part of the audit trail that Mr. Myers may be looking for?
Objection, Mariella Nassi.
Go ahead.
I don't believe that this is part of the record, and I believe that Ms. Padilla is essentially testifying here. I was not allowed to use material from another case. I believe that this should apply here. She's clearly reading from the record of some report, which none of us have. So I would object to this questioning.
Mr. Reynolds, yes, Mr. Reynolds clearly indicated he was familiar with these reports and he's reviewed these reports. So I think it's proper examination.
Sustained.
Okay, I'll move on. Okay, let me get back to my place. Well, let me ask you then in general, since I think it was also one of your recommendations, Mr. Reynolds, and let me find my notes. What type of documentation do you think PNM needs to provide to satisfy staff that the regulatory asset balance is like correctly calculated?
I believe, as Mr. Meyer recommended, that PNM should provide an audit trail documentation showing the list of RECs that are generated by Manzano, the status, their life status of where they are in their 4-year life, when they were retired, and against what compliance they were retired, RPS or Sky Blue, and the status of any expired RECs or the existence or lack thereof of a REC that expired and that was never allowed to be retired against a specific requirement.
Okay. In your direct testimony, your position is that while you supported PNM's recovery of the regulatory asset, you did not support any carrying cost at all. Is that right?
That's correct.
Okay. And have you seen anything in this case, whether it's in testimony, in the exhibits, that would change your mind about your position on the carrying cost?
No, not specifically. I did see the rebuttal of Mr. Baker that addressed that recommendation of mine. but relying on case 10-00018-UT, I could not find any explicit authorization for PNM to recover the carrying charge of 8.64% on an open-ended basis, time-wise and dollar-wise.
Okay. All right, I think I just have one last question. Mr. Myers made the suggestion that the question of whether the Sky Blue regulatory asset should be recovered in this case through the RPS rider should be deferred. I believe that was the position he expressed. Would staff be opposed to PNM's recovery of the regulatory asset once it's sufficiently proved up, in your opinion, in another setting, such as a rate case? And I know I'm springing that on you. Sorry, I just wanted to see if you had thought about that or could.
No. Staff would not be opposed to that. My concern is that by allowing this issue to linger, so to speak, that it puts ratepayers at more risk of a growing regulatory asset that's growing because the program is running at a deficit, and also because PNM is seeking carrying charges of 8.64%. So if there was a way to mitigate or put a freeze or some way of limiting the accumulation of that regulatory asset, I think that staff would be open to addressing this in the context of a rate case.
Okay. Okay, thank you, Mr. Reynolds. That's all I have.
Thank you.
Ms. Zewar? I don't think I see, oh, there she is. Do you have any questions?
Yeah, I'm looking at my notes. If I could have just a second, thank you. So, Mr. Reynolds, I understand you feel like PNM should have an obligation to mitigate the cost to ratepayers of allowing RECs to expire.
Yes, that's correct.
In 19-00159, do you recall, were you a witness in that case?
I was.
Do you recall, maybe it was an earlier case, so if I've got the case number wrong, maybe you can help me here. But wasn't there an issue with La Jolla being able to produce enough RECs to satisfy the 2020 RPS due to when it was going to come online in an earlier case?
In my recollection about La Jolla, and I assume you're referring to La Jolla number 2, is that La Jolla number 2 was approved in the 19-159 case as a procurement for RPS purposes, but it's not coming online until late this year or early next year. So it's there are no RECs being generated by La Jolla 2 this year, or if there are, they're very limited, to apply for 2020 RPS requirements.
And that's my recollection too, is that due to the change with the large customer cap, as a result of the amendments to the Renewable Energy Act, for 2020, PNM identified a REC shortfall in 19-00159. Do you recall that?
I recall that if I can step back one case earlier, the 18 case, I don't recall the digits after that, but in the 18 case, when PNM projected 2 years forward in 2020, the RPS requirement in that calculation is less than a year later in 19-159 calculations for 2020, the new calculations has a higher RPS requirements. I'm sure the large customer adjustment had an impact on that, but I think there was a number of other factors as well.
Sure. Maybe I could jog your memory. Do you remember there was at the hearing, there was evidence that indicated La Jolla would go into service near the end of 2020, and there would be something called test energy, something we couldn't count on, but may have possibly cured a rec deficit for 2020. Do you recall that?
I do.
Okay, so does that refresh your memory that there was concern there might be a rec deficit in 2020 that could potentially be cured by test energy from La Jolla 2 coming online before the end of 2020?
Yeah, I recall. I mean, that was part of the discussion. There was also some dispute about the calculation of the 2020 RPS, regardless of this test energy. But yeah, I do generally recall that.
Okay, so all I'm trying to get at is finally to the question here is, do you think there may have been an opportunity in the 2020 RPS plan or earlier cases to apply RECs that were actually needed rather than allow them to expire?
Yes, I believe correct.
Actually.
Okay. Mr. Durbin asked
Good
you
point.
about 1916.5. The commission shall not disallow recovery of cost associated with any expired renewable energy certificate. You recall that question?
I do.
Ms. Zur, that was actually asked, the question was not asked of Mr. Reynolds. It was asked of NM Area's witness.
Oh, forgive me. Let me rephrase my question. I'll just refer you. You are familiar with the provision in 62.16.5 2 that says the commission shall not disallow the recovery of the cost associated with any expired renewable energy certificate.
I need to find my version of the act here, just a moment. Can you give me the reference again? 62.16.
5, section 2.
Section 2. There's 5A, 1 and 2, B, 1 and 2. Not sure which section you're referring to.
It's 62.16.5. There's section B2.
Okay, letter B, number 2. Okay.
And it's at the end of section, the first paragraph in section 2.
Okay, I need a moment to read through this. Okay, I see it. And I recall the earlier questions about it.
Okay, sorry for being confusing before. So my question is, to comply with that statute, if the commission were to determine that does require recovery of the cost of those expired RECs, in your opinion, what should be included in that cost? Is it just the cost of the REC itself? Or should that include carrying costs? What does the cost mean for the purpose of complying with the statute? Again, with regard to expired recs.
And Mr. Reynolds, if you don't know, just say you don't know. I don't want you to speculate.
It's a difficult question for me to answer at this point. So I don't know.
Okay, thank you, sir. I don't have any further questions.
Okay, I think at this time, let's take a break. And let's come back at 11 o'clock.
We're taking a short break. We should be done within an hour. Okay. So, Steve. Yeah. How are they now?
Yeah, your legs feel like you have leg cramp.
You want to take a walk? You think that might help?
For what? No, cannot do that.
Fred, you're not muted.
Exercise bike, you sit on there and just pedal circular motion.
Yeah, because you like the hips and your
Yeah.
knees, but I cannot do that thing that you do. What's that thing?
So elliptical.
Yeah. Oh, yeah, your jacket goes nicely with your Karen white and blue shorts.
You like it?
I think you said not given me a email.
What?
I think you have not given me a email.
I have not yet. I thought we would do that when we gave him his shot when we're done with the hearing.
It should be, might even be delivered by the time.
You might be able to check to see if
I have.
it's.
It's not too far, it's from the South Capitol area.
Hey, Brad, you're not muted.
Allison, are you ready? Allison? Are you there, Allison?
I am, and
Okay, you're breaking up. Allison, are you ready to go on the record?
yes, I am.
Okay. Let's go back on the record. Before we resume cross-examination, Mr. Borman, I have a question. I just want to confirm, I don't need to delete Mr. Reynolds' supplemental testimony from Dropbox, I don't believe, because I don't believe there were any corrections to that. Am I right?
That is my understanding, yes.
Okay, thank you. Okay, Ms. Nanazi?
Thank you. Good morning, Mr. Reynolds. I have a couple of questions for you. Is it your opinion that the utility has a duty to mitigate its damages so that all ratepayers aren't subjected to a cross-subsidization of the under recovery of this regulatory asset?
Yeah, I would agree with that. That is part of my approach to my recommendation. I think that PNM needs to demonstrate that they acted in a reasonable and prudent manner in the accumulation of the deficit that shows up in the regulatory asset.
I have no further questions.
Mr. Gould?
I have no questions for Mr. Reynolds. Thank you.
Mr. Harris?
I have no questions. Thank you.
Ms. Yee?
No questions.
Mr. Reynolds, I have some questions for you. Did you read Shane Gutierrez's rebuttal testimony regarding your recommendation that PNM not be allowed to purchase more than 77,000 megawatt hours per year from the Lightning Dock facility without commission approval.
Yes, I did read it.
Do you oppose his position that PNM should be able to purchase more than 77,000 megawatt hours without commission approval if the excess is not used to comply with the RPS?
I'd like to refer to that particular section in his rebuttal, if you just give me a moment.
Sure.
Would you mind repeating the page number for that reference?
It is page 5 of his rebuttal testimony, lines 4 through 15.
Thank you.
I generally agree with PNM's position. I think it probably needs to be clearer that any of those purchases beyond the 77,000 megawatt hours need to be made at outside of the scope of the PPA, and these need to be separate arm's length market-based purchases, not just simply buying more energy at the same price as the PPA. So that I would add that clarification to the PNM position.
So in your oral testimony today, you recommended that PNM provide audit information recommended by New Mexico area. In connection with that, are you recommending that the commission defer a decision on PNM's request in this case to recover the Sky Blue regulatory asset until that information is provided?
My recommendation at this point is that that the commission act on the information that we now have in this case, and that PNM provide the audit trail documentation recommended by NM area for compliance verification purposes. And the reason for that, as I alluded to earlier, is that I'm reluctant to postpone a final resolution in this case because of the risk of an accumulating regulatory asset and accumulating carrying charges. Now, to the extent it would be possible to mitigate that or put a freeze on that, then I would be okay with deferring that to a later time, or perhaps a rate case as PNM's attorney suggested.
Okay. One of the 3 items that you identified, I think as a concern, are the swaps. And you recommended that that be addressed in the pending rulemaking. Do you have a recommendation on that issue in this case?
My recommendation in this case is that that practice is not entirely inconsistent with other practices relating to swapping RECs, so to speak, and that PNM was attempting to retire Manzano RECs before they expired, and that was a consequence of this balancing of wind and solar RECs for the Sky Blue program and the undersubscription into the program. So they were essentially forced to try to retire these RECs for RPS purposes. Otherwise, they would expire. But I think that there have been other instances where PNM has borrowed RECs from the future. In this case, PNM is lending RECs until it could maybe get them back in the future and apply them against the Sky Blue program. So I'm not opposed to deeming this practice to be acceptable and consistent with other things that have been done with RECs in the past for Sky Blue or even other RPS purposes.
You said with respect to the expired RECs that you think ratepayers should be held harmless. So does that mean you think the cost of those RECs, that PNM, the commission should not allow PNM to recover the cost of those RECs through the Sky Blue regulatory asset?
Yes, that's what I believe. And I think it might get a little complicated to figure out that calculation. But my recommendation is that, well, let me step back for a minute. I mean, I think Mr. PNM, when it's Babe, had said a few times yesterday that he didn't associate the RECs with the regulatory asset. And I mean, I kind of disagree with that in the sense that regulatory asset reflects the revenue requirements of a facility that's dedicated to generate voluntary solar RECs. So that's a large part of the regulatory asset. So to the extent that money is being spent and recovered from ratepayers to generate RECs, but those RECs expire unintentionally, I agree, but PNM should not, I mean, ratepayers should not pay for those RECs and then pay for the RECs that replace the expired RECs. I mean, that I think is a PNM avoiding responsibility for the expiration of the RECs. And in effect, double paying for RECs. The ratepayers will be paying for expired RECs and for the RECs to replace the expired RECs. I don't know if I answered your question. I'm sorry. If I didn't,
No.
follow up.
You did.
Okay, thank you.
That's all my questions. Thank you. Mr. Borman?
I do not have any redirect for Mr. Reynolds.
Okay. Ms. Zor?
I don't have any further questions. Thank you.
Ms. Nanazi?
No further questions. Thank you.
Mr. Harris?
No questions. Thank you.
Ms. Yee?
No question. Thank you.
Ms. Padilla?
No further questions for Mr. Reynolds.
Okay. Thank you, Mr. Reynolds. You're excused.
Thank you.
Mr. Borman, you may call your next witness.
Thank you. At this time, I would call Beverly Eschberger. Beverly, you're going to need to unmute yourself and put on your video. Beverly.
Yes, I'm here. I'm just having a little technical. There we go.
Why should you be different than anyone else?
But we thought we could get through this without technical difficulties.
It's a
Okay.
new world.
And let me turn on my lights here so that you can see me better.
At least we're not 5 years old and trying to get onto Zoom for a kindergarten class, right?
Yes, I think my son does better at this on his online classes than I do.
This is the reporter. Are you ready?
Yes.
Would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Good morning, Ms. Eschberger.
Good morning.
Whom are you employed and in what capacity?
I am employed by the New Mexico Public Regulation Commission as an economist in the utility division.
As part of your duties in that position, did you review the RPS filing by PNM along with the testimony filed in this case?
Yes, I did.
Based upon that review, did you prepare testimony regarding that filing?
Yes, I did.
You should have in front of you a document marked as Staff Exhibit 3. Do you have that document?
Yes.
Can you identify it?
That would be my direct testimony that was filed in this case on August 28th, 2020.
And was Staff Exhibit 3 prepared by you or under your supervision?
Yes, yes, it was.
Do you have any changes or corrections to that testimony?
No, I do not.
If I asked you today the same questions as are set forth in Staff Exhibit 3, would your answers be the same?
Yes.
Are those answers true and correct to the best of your knowledge?
Yes, they are.
Do you adopt Staff Exhibit 3 as your sworn testimony in this matter?
Yes, I do.
Madam Hearing Examiner, I move admission of Staff Exhibit 3.
Is there any objection? Staff Exhibit 3 is admitted.
Mrs. Eschberger is available for cross-examination.
Okay. Ms. Padilla or Mr. German?
PNM has no questions.
Ms. Zur?
CCA has no questions.
Ms. Nanazi?
No questions, thank you.
Mr. Gould?
Pnm area has no questions. Thank you.
Mr. Harris?
No questions, thank you.
Ms. Yee?
No questions. Thank you.
And I have no questions for you either. So Ms. Eschberger, you're excused.
Great, thank you.
And here I was looking forward to the extensive redirect.
I'm sorry, Brad.
Thank you, Ms. Eschberger.
And Mr. Borman, you may call your last witness.
Thank you, Madam Hearing Examiner. Staff calls Mark Tupler. And Mark, please unmute.
Hi there, I'm here.
There you are.
Madam Hearing Examiner, I believe you have to let me in.
Oh, I'm sorry. Okay, I just did.
Okay, hello, everybody. Technology.
This is very 2020.
Mr. Tupler, would you raise your right hand? Would you raise your right hand for me? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you.
Good morning, Mr. Tupler.
Good morning.
By whom are you employed and in what capacity?
I am an economist with the utility division at the New Mexico PRC.
As part of your duties in that position, did you review the RPS plan and application filed by PNM that is the subject of this proceeding?
Yes, I did.
Based upon that review, did you prepare or participate in preparing testimony regarding that filing?
I did, yes.
You should have before you a document marked as Staff Exhibit 4. Can you identify that document?
I've got it. It is my direct testimony filed on August 28th, 2020.
Was Staff Exhibit 4 prepared by you or under your supervision?
It was prepared by me.
Do you have any changes or corrections to Staff Exhibit 4?
Well, in addition to the hearing examiner's order that we discussed today, which will be done fully compliant, I've got two minor typographical errors that I'd like to address, page 11.
They are both on page 11 or the first one is on page 11?
The first one, page 11, line
Okay.
21.
Okay.
Should have a period instead of a close parenthesis.
Okay,
Page 16,
okay.
line 6. Requirement should be plural. Requirements.
Do those are all of your corrections?
Yes.
Okay. If I asked you the same questions as are set forth in Staff Exhibit 4, would your answers be the same as you have just corrected them?
Yes.
And as corrected, are those answers true and correct to the best of your knowledge?
They are, yes.
Do you adopt Staff Exhibit 4 as your sworn testimony in this matter?
Yes, I do.
Madam Hearing Examiner, I move admission of Staff Exhibit 4.
Is there any objection? Staff Exhibit 4 is admitted.
And I would note that we will make those corrections and make the additional changes to Mr. Tupler's testimony that are required. And file it at, or upload it, I should say, at the same time.
Okay.
Thank you. Mr. Tupler is available for cross-examination.
Okay. Ms. Padilla or Mr. German?
PNM has no cross for Mr. Tupler.
Ms. Zur?
CCE has no cross.
Ms. Nanazi?
No cross.
Mr. Gould?
Pnm area has no cross for this witness. Thank you.
Mr. Harris?
No questions of this witness. Thank you.
Ms. Yee?
No questions.
And Mr. Tupler, I have no questions either, so you're excused.
Thank you very much.
Thank you.
Another tough day at the office.
Yeah, right. Thank you, everyone.
That concludes staff's witnesses.
Okay, so that concludes the presentation of all witnesses. At this time, I'm going to order a bench request to PNM. And I'll go through this slowly because I'm not going to put this in writing. In light of New Mexico area's recommendation that the commission deny recovery of the Sky Blue regulatory asset in this case, so that I have a full record, I am ordering PNM 1 to revise the revenue requirement to be recovered under the 2021 rider rate to exclude recovery of the Sky Blue regulatory asset. So in connection with that, second, I'm ordering PNM to revise table TSB1 on page 5 of Mr. Baker's direct testimony to reflect removal of recovery of the Sky Blue regulatory asset from the rider. And table TSB1 basically lists the components of the revenue requirement and compares them to the 2020 revenue requirement. So all I'm asking is that that table be revised to remove the amount to be recovered for the Sky Blue regulatory asset. Three, I'm ordering PNM to recalculate the 2021 renewable energy rider rate to reflect that revised revenue requirement. And 4, I'm ordering PNM to revise exhibit HMP3 to Heidi Pitt's direct testimony, which is a bill comparison, to reflect the revised renewable energy rider rate for 2021. I'm not saying that I have made a decision on whether I agree with New Mexico area's recommendation, but I want, in case I do, and I recommend to the commission adoption of that position, I want to have a complete record to reflect that recommendation. And those revisions should be supported by an affidavit or affidavits. Does anyone object to those documents collectively being admitted into evidence as PNM Exhibit 10? Okay, hearing no objection, those documents will be collectively admitted into evidence as PNM Exhibit 10. And I'm going to order that those be filed by Wednesday, September 30th. With respect to briefing, I'm not going to require a brief from anyone, including staff. If you believe that your position has been adequately and clearly reflected through testimony, written and at the hearing, you can choose not to file a brief. But I will set briefing deadlines because I suspect some of you will want to file briefs. The statutory deadline in this case is November 28th. So in light of that, the deadlines for filing initial and response briefs will be October 8th for initial briefs and October 15th for response briefs. That's all I have. Does anybody want to raise anything before we go off the record? Yes, Ms. Nanazi.
Thank you. Should you decide to exclude the Sky Blue regulatory asset, I'm concerned with the point that Mr. Reynolds raised, which is essentially if this were to happen, then one of the issues though is that it continues to accumulate and with potential carrying charges of some degree, whether it's 0, I don't know, or 4% or the 8%. And so I'm wondering if your order will address that issue if you do decide that the Sky Blue regulatory asset has been denied.
I think if you want to, you think something needs to be done with respect to that contingency, you should raise that in your brief.
Okay, thank you.
Madam Hearing Examiner Peter Gould, I have a process question.
Yes.
Earlier, did you determine that the transcript is going to be expedited?
Yes, and
Yeah.
Allison told me that she believes it will be available next Wednesday.
Okay, and that will be on the Dropbox.
No, that will be on eDocket.
Okay, and with respect to your briefing order, the parties can decide to file one and not the other brief. Is that a fair reading of what you're ordering?
Yes, you can choose not to file an initial brief, but if you don't, you can still file a response brief.
Thank you, ma'am.
Anything else?
Madam Hearing Examiner,
Yes.
I said Wednesday at the outset. Am I to wait for PNM Exhibit 10 until I finish,
Oh.
or should I? Okay.
That's a good
Thank you.
question. No, I haven't answered that. That's a good question. In light of that, I'm going to change the deadline for PNM to file its response to the bench request to next Tuesday, which is September 29th. Thank you, Allison, for catching that. And that
Thank
should
you.
be uploaded to Dropbox. And why don't you also email it, please?
And file it as well?
Yes.
Okay,
Thanks. Good questions.
okay. So just so I'm clear, file it, serve the filing on the parties via email, and then also upload a copy to Dropbox.
Yes.
Okay.
Anything else? Okay, thank you all very much. I appreciate everybody's work and getting this to work over Zoom. And we'll go off the record. Thank you.
Thank
Thanks,
you.
Allison.
Thank you.
Thanks, everyone.
Thank you.